This is our second part 2 of the discussion. We were discussing the judgment of the CDF, judgment on the CDF Act 2013 by the Supreme Court. And so we want to proceed. So as you can see on my screen, I have shared the screen. We had seen the background of the CDF Act, and we had seen how the two of the petitioners, two NGOs, took the case to court. As you can see, the two petitioners were the appellants were Institute for Social Accountability and Center for Enhancing Democracy and Good Governance. And then the respondents were National Assembly, the Senate, Attorney General, Constitutional Development Fund Board, Commission for the Implementation of the Constitution, and Katiba Institute. And the court made a ruling. Remember, this was taken to court on in 2013, and the hearing came, the judgment by the High Court came in 2015, February. And so we want to pick from after that judgment, and you can see from item 11, note 11, agreed with the judgment of the High Court. And what was the judgment? What were the orders? The orders were that these were the orders. Number 6, you can see the trial court, by the judgment delivered on 20th February 2015, determined that the CDF Act 2013 was unconstitutional, and as a result, granted the following orders. Number 1, a declaration that the CDF Act 2013 was unconstitutional and therefore invalid. The order of invalidity above was suspended for a period of 12 months from the date of judgment. The national government could remedy the effect within the period of suspension, and the CDF Act 2013 would stand invalidated at the expiry of the 12 months, or could be earlier repealed, whichever came first, each party to bear its own cost. And so note 11 agreed with the judgment of the High Court. The first respondent, that is the National Assembly. The National Assembly filed a civil appeal number 92 of 2015, dated 16th April 2015, while the fourth respondent, that is the Constituency Development Fund Board, filed a civil appeal number 97 of 2015 before the Court of Appeal. The two appeals were consolidated and heard together. So the two appeals were consolidated and heard together. So you can see from this that the two appeals were consolidated. The respondents raised 23 similar grounds, stating in summary that the learned judges erred in law and fact. And so the 23 grounds are listed there. And they are listed there, they are summarized and listed there, you will be able to see. And so we find that the two, when they were consolidated, we were able to have now the issues as consolidated. The 23 issues were consolidated. The appellants raised, but you can see in summary what were consolidated, in finding that the CDF Act ought to have been considered by the Senate prior to its enactment, yet the Senate was not yet in existence. In failing to appreciate the CDF Act, Amendment Bill 2013 was not a bill concerning counties, And so those issues were consolidated to come up with A to H. That is about 7 issues. Let me see, that is 4 plus 4, about 8 issues. They are consolidated into 8 issues. The appellants raised a preliminary objection. So the appellants are the ones who won in the first round because they succeeded in having CDF Act 2013 declared unconstitutional. And so when the respondents went to court, they raised an objection, raised a preliminary objection to the 2 appeals, challenging the Court of Appeals jurisdiction on the ground of mootness. And so there were issues that they raised, as you'll be able to see. And so we find that that was determined. They were told that these issues would be addressed later. The appellant's court directed, as you can see here, the appellant's court directed that the preliminary objections be determined together with the substantive appeals. So they were ordered not to worry that the same would be determined at a later date. Now, having considered the issue, the Court of Appeal delivered a judgment on 24th of November 2017, actually allowing the appeal by declaring sections 24, subsection 3C, F, and 37A of the CDF Act unconstitutional and invalid for violating the principle of separation of powers. So you find that from 2015, when the first judgment was made by the High Court, then there was an appeal. Then the Court of Appeal now is making their judgment on the 24th of November 2017. It's not, it is worth noting that this appeal is coming at the beginning of the of the 12th Parliament, because we have just had, at this stage, we have just had the 2017 elections. And so the next Parliament is coming to office. But cleverly, or in compliance with the directions of High Court in the 2015 ruling, that the unconstitutionality of section of CDF Act 2013 was suspended. The unconstitutionality was suspended and was given 12 months so that the national government would remedy the situation. And so even though in 2017 now, it is like, it is closed that this section, this act is unconstitutional. There was already another act, that is End of CDF 2015. And so this back and forth in court, in my opinion, was just a matter of law and fact and determining, but it would not stop the operations of the CDF that we know, because there was already an NG CDF, the national government CDF, solving and correcting all the issues that have been raised in the High Court within the 12 months that was allowed. But now that is something else. Let us just narrow down to this and focus and understand really what happened. And so we have had the second ruling where those three sections have been pronounced, have been declared unconstitutional. But I want us to see those three sections, so that we are able to understand. So that is section 24. Let me just search 24 here. This is the act itself. And you can see section 24. We are being told section 24, subsection 3. So this is section 24. Let us see subsection 3, C and F. So what does section 24, subsection 3 say? It says the 8 persons referred to in subsection 2, B, C, and D. Let us see those one. B, where is B? B, 3 men nominated. This on composition. On the composition, as you can see, on the composition of the CDF Constitution Development Fund Committee. Yeah, so we find that on that composition, D, 1 person. Let us see C says 3 women nominated by the ward development committees, and one of whom is a youth. D is 1 person with disability nominated by the ward development committee. So it is B, C, D, and E. Let us see B. B was saying 3 men nominated by the ward. C, 3 women nominated by the ward. D, 1 person with disability nominated by the ward. E, 1 person nominated from among the active NGOs in the constituency shall be nominated through the following procedure. And so what was declared unconstitutional was subsection 3C. So let us go straight to C. C says, upon receiving the names from all the wards in the constituency, the member of parliament. And so that is where the problem is, the member of parliament. So this was declared unconstitutional. Yeah. The member of parliament, in consultation with the office of the board, and the sub-county administrator for the constituency shall appoint 8 persons. And then let us see what F is saying, sorry. Let us see F. F is saying, upon consultation of the election, conclusion of the election of the chairperson in the manner stipulated in paragraph D, the office of the board shall forward the names of the 10 members of the Constitution Development Fund Committee to the Chief Executive for onward transmission to the Cabinet Secretary. No, that is E. That is not declared. That is correct. We are supposed to refer to F. There's where F says the member of parliament for the constituency shall be an ex-official. So that was also found to be unconstitutional. And then we have 37 subsection 1A. So we go to 37 subsection 1A. It says the senator or member of parliament of the county, that is like the member of parliament from the members of parliament from the county, that is like all members of parliament of the county women rep, and the governor. These are the people the members of the county projects committee. And you see, this one was now widening the scope, because CDF, as we know it, is money given to a particular constituency. But now you are going to have the senator, the member of parliament, members of parliament from all the constituencies. So it was really going to be a big. It is like all the members of parliament will be involved in every CDF fund per constituency. I think that was actually regular, but we are happy that the Court of Appeal also delivered and judgment and found that unconstitutional with regard to the principle of separation of powers. Then the court also overturned the declaration that the CDF was unconstitutional in its entirety. So they disagreed that it was overly unconstitutional, that the rest of the orders made by the trial court had been overtaken by events. That is the essence I was saying, that because we already had the NGCDF. And so we find that after the Court of Appeal delivered this judgment, there is explanation, as you are going to see. You see, once a judgment is given, then there must be now the details of the same, and that is given there. So you'll see the details up to, say, note 20, note 19, and then dissatisfied with the Court of Appeals decision, as you can see, you find that we are now told that we can see that the Court of Appeals decision, the appellants filed an appeal against the court. Appeal before this court, as alluded to the opening paragraph of this judgment, where they were seeing, whereby they are seeking inter, meaning among others, the following orders. And now this court being referred to here is now the Supreme Court, that they dissatisfied, the appellants filed an appeal before the court, the Supreme Court. So the appellants are the two NGOs. They filed an appeal here because they felt that by the Court of Appeal suggesting that, ruling that only sections of CDF Act 2013 was unconstitutional, they felt that it was unconstitutional in its entirety. And so you find they have given, they were seeking the following orders, which are listed there. A number of orders that they were seeking. They were they wanted the court to make some orders as listed there. Then we find that dissatisfied with the decision of the Court of Appeal, the first respondent filed notice of cross appeal dated 6 December, seeking intalia. Other issues there you can see. Then now the party submission. So from here now, you'll be able to see that now the parties will now make their submissions in court. So beginning with the appellants, you will see the appellants will make their submissions, and they will submit. The appellant submissions are dated 5th February 2020 and filed on 6th February 2020 on the issue of mootness. So they pick one issue and they argue their case. You see 22 on the issue of justiciability. The appellants argue that the Court of Appeal erred in court's approach to justiciability question, which is addressed under the twin limbs of the principle of ripeness and all that. And so you'll be able to see the explanation, details of that. Further, the appellants faulted the Courts of Appeals for misinterpreting and misapplying the provisions of Article that. So they pick every issue and they address. So that is the appellants. And then we see the first respondents case. The first respondent comes in and also makes the case. And you'll see back and forth. They make their case. In conclusion, the first respondents are submitted by the appellants. Court erred in failing to appreciate the members of parliament, the CDF, WAEX, official members without voting rights. So you see the first respondent, that is the parliament, they are trying to defend their position, and they're saying the members of parliament are simply ex-official members without voting rights, and that the representation of the electorate includes allowing the elected members to articulate issues and views of the electorate. So that was among them. Then now the fourth respondent, that is the board. The CDF board also came in and they opposed the petition through its submission that on the issue of mootness, they explained all, they did their submission. And so the fourth respondent submitted that the CDF bill 2013, precursor of the CDF Act 2013, concerned the funding of functions outside those specified in the fourth schedule, and therefore failed the test of being considered as one relating to county government. They're trying to say that this fund is not related to county government, and they're trying to explain that this outside the issues raised. Funding was specified in the fourth schedule of the Constitution. And so that is there. We have now seen both the respondents and the appellants and the respondents have now made their case. And so the analysis and determination now, the court now, having considered the respective parties, you see now having considered the respective parties and submissions of the appeal and cross appeal before us, the following issues emerge for determination. And so it is normally the court now listens from both sides, and now makes a determination, deciding what exactly are the issues before us in our analysis and determination. And so the court narrowed down, and you are able to see there the issues that were decided were they felt were clearly before the court. And so these are the issues that the court will make a determination on, whether the Court of Appeal, the appeal before the Court of Appeal was moot, whether the CDF Act as amended is unconstitutional, whether the CDF Act 2013 offends the constitutional design, whether the CDF Act offends the division of functions between the national and county governments. So those are the issues that were there. And then they first issue and address it. You see that? They pick the first issue and address, and they will pick all the 7 issues and address them. And so it's clear that you can see the details, and on the issues, every issue they take and they discuss. And so I want to just take us forward so that we are able to make some progress. That you will find the arguments by the Supreme Court on a number of areas and comparing and mentioning cases all across the board, across the other cases being referred to, not only in Kenya, but even globally, especially in the Commonwealth countries, trying to argue their case. For instance, you can see in paper v. Hart, 1992, the purposive approach to legislative interpretation has evolved to resolve ambiguities in meaning. So they are using other cases. We see like the case of Peter Munya versus Dixon Mwenda and 2 others. Yeah. So there are quite a number of very elaborate explanations that the court gave in coming with their decision. I want to take us to just section item 83 or note 83, so that we learn something special there, which I felt was important. It is clear from the above provision that the Constitution does not grant the National Assembly powers to implement projects as a service delivery unit at the county level. Members of the National Assembly are granted the mandate to legislate and oversee the national revenue and its expenditure. So this is removing the members of parliament from being engaged in implementation of projects, okay? So that is very important. Let us see 89. 89 is saying that, also I found very important. This paves the way for us to determine the question initially posed, which is whether by straying its functional areas assigned to, whether by straying into functional areas assigned to county governments, the CDF Act violates the division of power between 2 levels of government as provided under the Constitution. Those are very important questions that they are going to determine. And they are saying that the CDF has strayed into functional areas assigned to county governments. That's very important. That's very, very important. And 90 says, we note that the Court of Appeal found that the CDF did not violate the powers, the division of powers between the court of 2 levels of government, and alluded to the possibility the CDF amounted to an intergovernment transfer function. With tremendous respect to the learned judges, we do not think the CDF amounts to an intergovernmental transfer of functions. In other words, they're disagreeing with the Court of Appeal, and they're giving their submission. They say, in our considered opinion, the Constitution pays keen attention, to ensure that the national government does not usurp the mandate of the county government by specifying a clear process for the transfer of functions from a county government to the national government. And so, in a way, they have differed with the Court of Appeal, and they are saying that it's very clear that there was a violation with regard to division of powers between the two levels of government. And so that is just to give a hint. I mean, a bit of the explanation that were done, but I want to drive us straight to the final conclusion that the court had. We see in Note 35 that the court made a determination, and this is the determination. And that is the final ruling and the orders that were given. In Note 35, it says, having fully considered the issues delineated by the court for determination above, we find as follows. The Court of Appeal, the appeal before the Court of Appeal was not moved. Meaning it was active. It was not passed by events. It was not suspended. So it was active, and it was rightly before the court. That is the basic understanding. The court, the CDF Act 2013, as amended by the CDF Act 2013, as amended by the CDF Amendment Act 2013, is unconstitutional. Unconstitutional on account of procedural lapses for failing to involve the Senate in its enactment. Okay? The CDF Act does not offend the constitutional design, and the CDF Act offends the division of functions between the national and county government as it is. I agree with this. The CDF Act 2013 offends the constitutional principle of the division of revenue. The CDF Act 2013 offends the constitutional principle of public finance. The CDF Act offends the constitutional principle of separation of powers. Okay? And so those were the findings of the court. And let me just see, we find as follows. Yeah, that's what I wanted. So those are the findings of the court. Yeah. And then now the orders are as follows. Consequently, we issue final orders. And when you say final orders, these are the final orders. When the Supreme Court says it is illegal, it is unconstitutional, it is unconstitutional. The appeal dated 29th November is allowed, December 2017 is allowed. The cross appeal issued on this is disallowed. A declaration is hereby made that the constituency, this is a declaration, is hereby made that the Constitutional Development Fund Act is unconstitutional. And so this one is very clear because the Court of Appeal had found that sections of CDF Act 2013 were unconstitutional. But now the Supreme Court has said that the Constituency Development Fund Act 2013 is unconstitutional. That is in entirety. Okay? And then he says that each party to bear its own cost. And you see that was delivered on the 8th day of August 2022. It is supposed to have been signed. Yeah. So this is a soft copy. M.K. Kome, that is the Chief Justice. We have P.M. Wilo and all the judges, the other judges are there. So we see that what is now the fate of the CDF Act? The CDF Act 2013, as declared here, is unconstitutional. It is so determined and found And it is good, sometimes people go to court, not necessarily to win cases, but to find a proper closure to that particular case. And so I think on the constitutionality of the CDF Act 2013, that matter is now closed. And so it is important that we appreciate that it is closed. And now, does it mean that the concept of the CDF that was, we know, no, we in the streets, we don't say CDF Act 2013, we just say CDF. So is CDF closed? No, because there is a CDF Act, NG CDF 2015, that already corrected all the discrepancies, all the contradictions which were in the CDF Act 2013. And so in my opinion, the CDF Act 20, NGCDF Act, that is National Government Constitutional Development Fund, Act 2015 is rightly in place and will continue to operate. What has been done is that the hands of the members of parliament has been removed from operation, from implementing the projects. You can't stop them from coming to the CDF office. You can't stop them from being engaged because they are also members of that constituency. But in terms of their role, it is clear that the CDF Act 2013 gave them a lot of roles, even though to say that they were ex officio, but the CDF, the Supreme Court has determined that it was against the principle of separation of powers. And so that is I've tried to run us through so that we have a feel of the whole judgment. You can choose to read it yourself, sections, so that for your purpose of your understanding. But I found it proper that we share so that we are able to understand what exactly did the Court of Appeal, the Supreme Court, make a determination on. So thank you very much. And I want to request that you subscribe to our channel, and so that every time we go live, you are able to see, you're able to get a notification.